Assalamualaikum. Hi, I'm Fakhrul from Dai's Daily News. As for your reporter today, I'm going to present to you about consideration under the law of contract. Consideration under the law of contract would be subdivided into three types. The first one is executed consideration, the second one is executory consideration, and the third part is past consideration. For now, let us see for the first part, that is executory consideration.
Hi, welcome. May I help you?
Ika, I want this. I'm so hungry right now.
Okay, it's on me. How much is it?
This is 2 ringgit.
Okay, let us move on to the second part of consideration, which is executed consideration.
Hi, do you see my phone?
No, sorry.
Okay, thank you. Najihah, I lost my phone. I can't find it. Did you see my phone?
No, where's the last time you put your phone?
I can't remember at all.
Okay, let me spread the news about your phone.
Are you Liana? Yes, I am. I heard that you lost your phone.
So, I think this one is yours?
Oh, thank you so much. I've been searching my phone everywhere. So, this is your reward.
Wow, thank you.
Okay.
As you can see, this is an executed consideration where the promise is made in return for performance of act. Okay, let's move on to the third part of consideration, that is past consideration.
Hi, Najihah. What's wrong?
Hi. Actually, I want to start a business about baking, but I don't have any skills in baking. Do you have any idea?
Oh, I think you can use my secret recipe book.
Wow, that's so nice of you. I'm desperately needing a recipe book for my business. I'm really grateful for your recipe book. It really does help boost my business. I promise to give you 1% of my profit to you.
Oh, really? Thank you so much. I come to claim my reward.
No, I'm not giving you any more reward.
See you in court.
This situation is considered as a last part of consideration, which is past consideration, where the promise is made from a subsequent act from another promise.
Assalamualaikum warahmatullahi wabarakatuh. Hi, I'm Najihah from Dai's Daily News, here to share with you a case under Section 26, exception under consideration, which is an agreement made on account of natural love and affection between parties standing in near relation of each other and registered. Let us see. Sis, are you okay?
No, I need my seat.
Shida,
Yes.
when I die soon, please transfer all my property to my adopted child.
Okay. I will.
So, as you can see here, this is an agreement made on natural love and affection between parties standing in near relation and registered.
Hi, Assalamualaikum warahmatullahi wabarakatuh. I'm Athikah from Dai's Daily News, here to let you know the case of Section 2, Subsection D of consideration, where consideration need not move from the promisee. Okay, let's see the situation where the consideration can come from the other party.
Son, come here.
Okay, sons, since you are the eldest one, I'm giving the land to you, and by that you have to pay an annuity to your sisters.
Okay, sure, mother.
Fakhrul, since our mother has already gone, so we want to claim our share of the annuity that mother has already passed on to you.
But why should I? Mother gave that piece of land personally to me only, and that doesn't include both of you.
Oh, this is unfair. She's my mother too, and we still want our share of the land. Don't make me take this case to the court.
Fine, do as you please.
So, this is a scene that shows consideration also can come from other party.
Hi, Assalamualaikum. I'm Liana from Dais Daily News, here to share a case about adequacy of consideration, which is consideration need not be adequate as long as it is freely given. Let's observe.
Hey, Shida.
Yes?
I'm kind of desperate needing money right now. So how about I'm selling you my phone?
How much are you going to sell your phone? Because currently I'm having a problem with my phone too. What a coincidence.
I just bought this phone for like 2 months ago, and it's around 2,000 ringgit, I think. So as a friend deal, I'm going to sell you 900 ringgit.
Okay, deal.
Okay, so this is a scene that shows adequacy of consideration, where consideration need not be adequate as long as it is freely given.
Hey, you know what? Actually, I feel so stupid for selling you my phone for that price. So I came here to take it back.
Is that possible? Because you are the one who set the price.
Yeah, that possible.
Hey, who do you think you are? Are you thinking of taking the phone back? I'm gonna sue you. See you in the court.
Assalamualaikum warahmatullahi wabarakatuh. Hi, I'm Syahida from Dais Daily News, here to share with you about intention to create legal relation. So, let us see.
Honey, I have bad news for you because my company had me transferred to Sweden because to help with the company branch over there.
Are you serious? So you are going to leave me here alone by myself?
Yeah, honey, you will be okay. So 2 years won't be long, okay? I gotta go.
So much for a business trip, man. Who is this woman?
Look, honey, I can explain this.
After 2 years, you left me back in Malaysia alone, and suddenly you stopped giving me my allowance. Explain that.
Look, as a man, they can sometimes feel lonely. So I got her right now.
So, this is a scene of social, domestic, or family agreement that fall under intention to create legal relation.
Assalamualaikum warahmatullahi wabarakatuh. Hi, I'm Fakhrul. For today's presentation, I'm going to present to you consideration under the law of contract, which is executory, executed, and past consideration. Okay, for consideration can be anything of value which each party to be a legally binding contract must agree to exchange if the contract is to be void. There are 3 types of consideration, which is executory, executed, and also past consideration. Let's move on to the first part of consideration, which is executory consideration. Executory consideration is when one promise is made in return of another. For example, Shida and Ika purchased goods from the pushcart. Ika gave the money to Jihar, which is the cashier, and Jihar gave the purchased good to Ika. This shows that it consists of promise to do or abstain from doing something. Okay, let's move on to the second type of consideration, which is executed consideration. Executed consideration is when a promise is made in return for the performance or an act. For example, for the previous case, Liana offered 100 ringgit to anyone who found and returned her handphone by viraling the offer on the social media. Shida, who returned the handphone in accordance with the offer, constitute the required consideration. So, Liana has performed the part of the consideration by paying Shida 100 ringgit. It shows that it consists of doing an act. Okay, let's move on to the final and the last part of consideration, which is past consideration. Past consideration is where a promise is made subsequent to and in return for an act that had already been performed. For example, of the previous case, Ika gave her secret recipe book to Jiha when she knows that Jiha wanted to open a bakery. But sadly, Jiha doesn't have any skills in baking. After the bakery was formed and the business was a success, Jiha and Ika entered into an agreement when Jiha promised to pay Ika 1% of every piece of cake that she sold. Jiha broke her promise and Ika sued her. Ika succeeded in her action because this was clearly a past consideration and it did constitute a valid consideration. Ika was entitled to her claim on the amount. Okay, that's all from me. Thank you so much.
Assalamualaikum warahmatullahi wabarakatuh. I'm Najihah. Today I'm going to present to you the exception under consideration. Okay, in the consideration, there is an exception which is first, an agreement made on account of natural love and affection between parties standing in near relation to each other and registered. Refer to the case of Ri Tan So Sim, which is a woman on her deathbed expressed her intention to leave all the properties to her 4 adopted children. The court held that the claims of the adopted children were not effective as it was contrary to section 26 subsection A, as there was no in writing and there is no natural love and affection between parties standing in near relation to each other and registered. This is same with the example which the mother expressed her intention to leave the properties to her adopted child to her siblings. Although the agreement between siblings is in writing, the agreement was come from her mother's sibling and they are not close with the adopted child, so the contract is void. Okay, for the second one, an agreement to compensate for a past voluntary act and an agreement to compensate a person who did an act which the promisee was legally compellable to do. Okay, for the last part, which is the third exception, is an agreement to pay a statute-bearer debt. A statute-bearer debt refers to a debt which cannot be recovered through legal action because of a lapse of time fixed by the law. Section 26 subsection C creates an exception to this rule but subject to several conditions. If the debtor made a fresh promise to pay the statute-bearer debt and the promise is in writing and signed by the person to be charged in his or her behalf, so the contract is formed. Okay, so that's all by me. Thank you.
Hi, Assalamualaikum warahmatullahi wabarakatuh. I'm Athikah. Today I'm going to present to you a consideration did not move from the promisee. Section 2, subsection D of Contracts Act 1950 provides that a party to an agreement can enforce a promise even though he has given no consideration, as long as somebody else has done so. For example, Fakhrul agreed to pay an annuity to her sisters who provided no consideration for the promise. On the same day, his mother had given Fakhrul some land, stipulating that he must pay annuity to his sisters. Fakhrul, however, subsequently failed to pay the annuity and was sued by his sisters. The court held that he was liable to pay for the annuity. There was a good consideration for the promise since his mother is the one who gives the consideration. Okay, thank you.
Assalamualaikum and a very good evening to Madam and all the viewers. I'm Nur Syahida Bt Ibrahim, going to present the viewers of performance. The general rule in English law is that waiver of a right that is not supported by consideration void. For example, Alia owes Suzy 1,000 ringgit which is due. Suzy asks Alia to return 100 ringgit in full settlement. The waiver is not binding on Suzy, who may later change his mind and claim the balance owing, because the promise to forgo the balance is not supported by consideration. A person who does no more than what he is already legally obligated to perform or under a public duty to perform cannot hold the other party to his promise. Payment of a smaller sum is not satisfaction of a legal obligation to pay a larger sum. refer to case of Penal 77 ER 273, see Section 64 Contract Act 1950. It says that every promise may dispense with or remit, wholly or in part, the performance of the promise made to him, or may extend the time for such performance, or may accept instead of it any satisfaction which he thinks fit. For example, Ahmad owes Razak 5,000 ringgit. Ahmad pays to Razak only 200 ringgit, and Razak accepts in satisfaction of the whole debt 2,000 ringgit paid at the time and place at which the 5,000 ringgit were payable, the whole debt is discharged. See case of Kapal Singh versus Baryam Singh. Baryam Singh owed 8,896 ringgit and 64 cents under a judgment that Baryam Singh's son wrote to Kapal Singh offering 4,000 ringgit in first settlement of his father's debt and endorsed a check for the amount. He stipulated that should Kapal Singh refuse to accept, he must return to check. Kapal Singh legal advisors having cashed the check and returned the money proceed to secure the balance of the debt by issuing bankruptcy notice of the debtor. The Federal Court ruled that the acceptance of the check from the debtor's son in full satisfaction preclude them from claiming the balance. Thank you.
Hi, with me again, Athikah. Okay, so I will present adequacy of consideration. There is no requirement that the consideration must be at market value, as long as the promise provides something in value. The courts are not concerned to the adequacy. For example, Fakhrul wanted to sell his phone to Shida because he needs money immediately. Shida agreed to buy the phone on the agreed amount. Weeks later, Fakhrul met Shida because he wanted his phone back since he sold it under market value. However, Shida refused to give and sued Fakhrul. Shida succeeded in this case as consideration need not be adequate as long as it is freely given. Okay, thank you.
Assalamualaikum. My name is Liana. Today I'm going to present about intention to create legal relation. As well as we know, intention to create legal relation is part of elements in contract. Intention to create legal relation is defined as an intention to enter into a legally binding agreement or contract. Not every agreement leads to a binding contract which can be enforced through the courts. In order to determine which agreements are legally binding and have an intention to create legal relation, the law draws a distinction between business agreement and social, domestic, or family agreement. In business agreement, the parties intend legal consequences unless specified otherwise. Based on the case of Ross and Frank Company versus Crompton Brothers, the claim defendant entered an agreement for supply of some carbonized tissue paper. The contract contained a honorable pledge clause which stated the agreement was not a formal or legal agreement and shall not be subject to legal jurisdiction in the law courts. The court held that the contract is not valid as the agreement has no legal effect and was not enforceable. In the term of general rules of social, domestic, or family agreement, there is no presumption to be legally binding. Otherwise, in terms of exception, the presumption is rebuttable. For example, Fakhrul worked overseas and agreed to give £30 to his wife, Liana. However, the relationship later soured and he stopped making the payment. The wife sought to enforce the agreement. The court held that the contract is not valid because the parties did not intend to be legally bound. This case is similar with Balfour versus Balfour. Compared to the case of married versus married, the agreement was binding since the parties were separate. Where spouses have separated, it is generally considered that they do intend to be bound by their agreements. The written agreement signed was further evidence of an intention to be bound, so the contract is a valid contract.